video, I simply want to introduce some basic theories of constitutional interpretation. We'll discuss these theories in more detail in future videos. In presenting this account, I want to focus on a specific part of the Constitution. Specifically, the Eighth Amendment in the Bill of Rights states, quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted," end quote. So, when is punishment cruel? What types of punishment violate the Constitution? And I want to consider four options. The first option, cruel means whatever the judge thinks is cruel. Under this interpretation, the Eighth Amendment is telling judges, do not allow any punishment that you think is cruel. The main argument in favor of this option comes from a view called legal realism. Legal realism holds that the law is whatever the judge says it is. Sure, there's an appeals process where what a lower court judge says can be overruled by a higher court, but in this case, the law is whatever the members of the highest court say the law is. And this means that the Supreme Court gets to determine what the Constitution says. Now, basically, this is a descriptive claim. It says that, like it or not, this is how the law actually works. What happens is that a judge first determines what they want the law to say, then the judge comes up with some convoluted argument, cherry-picking cases and interpretations in order to get the conclusion that the judge likes. And once the judge or the Supreme Court delivers an opinion, that's it. That's now the law of the land until the judges change their mind. So let's consider some objections to this view. There's no denying that judges sometimes rationalize. That is, they argue from the conclusions they like to the premises that support their favorite conclusion. Judges are human, at least until AI gets better developed. Then you can have your case judged by a chatbot. But this falls far short of saying that this is the essence of judicial decision-making. Scientists rationalize as well. They're human. But that doesn't prove that scientists don't care about the evidence and never let the evidence determine their conclusions. Legal realism would seem to imply that if the legislature changed the law, this would not affect judicial decisions, since the judge will still interpret the law to get their desired conclusions. But of course, we do find changes in the law resulting in changes in judicial behavior. We're actually not going to spend much time on this option. It was popular in the early 1900s and still held by some cynics today, but it doesn't have much philosophical credence. The second option says that a judgment is cruel if the people who wrote and passed the Eighth Amendment would have thought that it was cruel. The judge's job is to enforce the law as written. If people want to change what counts as cruel, there are procedures for amending the Constitution to do just that. Until they do, the meaning of the Eighth Amendment was decided when it was written. Judges have no legitimate authority to change the law. This version is typically called originalism. Originalism says that the Constitution is to be interpreted like any set of instructions. Gary Lawson introduced an analogy in 1977 to explain this method of interpretation. Assume that you're going through some boxes in the attic and you found a chicken recipe written in 1790. The recipe tells you how much of various ingredients to use and instructions for temperature and cooking time. Understanding what the recipe says involves understanding what the terms meant in 1790. A pound of chicken is determined by what pound meant in 1790. If it says to add pepper, then you add what people in 1790 would have called pepper. If you use something else, you can't truthfully say that you are following the recipe. The Constitution is a recipe for running a government. To follow the recipe, you follow the public meaning of the instructions. If you do something else, then you're not following the Constitution. What are some problems with this theory? There's a set of objections that ask the question, why should we be confined to the dead hand of the past? A bunch of white, mostly slave-owning rich folks leaves us a set of instructions telling us what to do. Why should we follow those instructions? If we fix the meanings of the terms in the Constitution to the age of muskets and plows, the Constitution will quickly become outdated and irrelevant. When it comes to fixing fried chicken, there's no stigma attached in deviating from the recipe, particularly if the resulting chicken tastes better. Again, we're going to look at arguments and objections in more detail in later videos. This is just to give you a rough idea of the views we'll be covering. A third option is that for punishment to be cruel, it must be something that people living today judged to be cruel. Note that there's an important distinction between this and what the judge thinks as cruel. Under this option, the judge is to look for some sort of public consensus, even if the judge disagrees with that consensus. The judge may personally object to capital punishment, but, regretfully for the judge, admit that the judge lives in a society that accepts and endorses capital punishment. This view is typically known under the title Living Constitution. It holds that the Constitution should be viewed as a living document capable of evolving so as to fit a changing world. It takes seriously the objection that originalism will make the Constitution archaic and outdated, and it tries to extend the life of the Constitution by shaping it to meet current problems effectively and efficiently. But there are also objections to this view. One powerful objection is that unelected judges should not be writing new law. Ultimately, it's up to the people, acting through their elected representatives to make new law, not judges. The legislature makes the law, the judge applies the law to specific cases. If changes to the Constitution are needed, there's an amendment process. There should not be a second amendment process that says the Constitution shall be amended if judges acting in their normal capacity as judges decide to change it. Note that this means that if people living today decide that, for example, the president should be free to arrest and imprison political rivals as they please, then the Constitution allows for this. If people living today think that such practices are legitimate, then they are legitimate. The last option to consider may be called the moral facts option. What counts as cruel in terms of cruel and unusual punishment doesn't depend on what people living 250 years ago thought was cruel, nor does it depend on what people living today think of as cruel. There's a fact of the matter. There is evidence that the authors of the Constitution did not believe that they had the right or the power to determine which rights exist. These rights exist as a matter of fact. They're not invented. They're discovered. The First Amendment doesn't say we grant to the people a right to freedom of the press. It says there exists a freedom of the press, and the government shall not violate it. It is as illegitimate to determine the extent of a right by looking at beliefs as it is to determine the size and age of the earth by studying beliefs. As for objections, how are we to deal with the fact that people have very strong moral convictions that don't always agree with each other? Take, for example, the first section of the 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Does the term person apply to a fetus? Does it apply to animals? The authors of the 14th Amendment may have intended it to apply only to human beings born or naturalized within a state. Well, actually, they probably meant it only to apply to men born or naturalized within a state. But moral fact theory doesn't care what people believe. They are about whether something really is a person. In the same way that the 14th Amendment was expanded to include women, can it not be expanded to include a fetus or animals? And at what point does artificial intelligence become a person within the scope of the 14th Amendment, with rights according to the Constitution, when the authors of the 14th Amendment would have granted them personhood, or when they in fact acquire those qualities that define something as a person? Allowing that these are tough questions to answer, should it be up to judges or the legislature to settle them? These, then, are the four major theories of constitutional interpretation that we'll be looking at. We'll take up the dispute in more detail, starting with originalism, in the next presentation.